In this episode, I would like to discuss about the concept of agreement and contract in accordance with the Indian Contract Act 1872. Both the words agreement and contract are defined in the Indian Contract Act. There are similarities, but there is distinction as well. So, agreement and contract both are similar in nature, but there are differences also. So, what are the similarities and dissimilarities between these two terms of the Indian Contract Act 1872, that is agreement and contract? That is the topic of discussion today. And in this episode, I would like to discuss about the scope or ambit of section 10, that what is the circumference of section 10, how much broader it is, and how much section 10 is connected with various other sections of the Indian Contract Act. That is also subject of discussion today. Section 2 of the Indian Contract Act deals with the interpretation clause. This section 2 defines various words, and section 2 clause E defines the term agreement. So, it says that every promise and every set of promise forming the consideration of each other is an agreement, and clause G of section 2 deals with the term that is void agreement. An agreement which is not enforceable by law is void, and H speaks about the contract. That means, if any agreement which is enforceable by law, that is the contract. So, section 2 deals with that both term, that is agreement and contract. If the agreement is not enforceable by law, then it is void, but if it is enforceable by law, it becomes the contract. So, I would like to discuss about now section 10 of the Indian Contract Act, which deals with which agreements are contract. So, in order to become the contract, an agreement must have the essential requisites. What are those requisites? I would like to discuss at first. Section 10 says which agreements are contract. That means, if the agreements are made with free consent of the parties who are competent to contract, with a lawful consideration and with a lawful object, and not otherwise declared to be void. And apart from that, it may be registered or it may be written if that is required by the law, and witnesses are also required if it is required by the law. So, these are the essential ingredients of section 10 which must be required. So, let us have a look that what I have stated, that section 2 it is dealing with the interpretation clause agreement, void agreement and contract, E, G and H, and so it is connected. Now, section 10, that what agreements are contracts. Now, there are basically 8 ingredients, that is competent parties, free consent, lawful consideration, lawful object, not expressly declared to be void, to be made in written if required by law, otherwise oral, witnesses are necessary if required by law, and registration is necessary if required by law. And we know that 3 basic elements are required for formation of any agreement, that is offer and acceptance and consideration, which are very much requisite for formation of any agreement. So, let me discuss at first the each ingredient in a brief manner. That is, first is competent parties, that is mentioned in section 11 and 12. So, section 11 says that who are competent to contract. That means, in order to become the competent for contract, the parties must be mature. That means, he has attained the age of 18 years. So, that is the according to the Indian Majority Act. So, if they are becoming major, they can enter into the contract. So, competent party means contracting parties have attained the age of majority. Ordinary cases, the majority age is 18 years according to the Indian Majority Act, but if the guardian is appointed by the court, in that case that is 21 years. So, 18 years in ordinary cases, or 21 years if the guardian is appointed by the court, is the age of majority. That means parties are becoming competent to enter into the contract. And apart from this, there is another condition, that is soundness of mind. So parties must be mature as well as sound minded, who are considered as competent parties for entering into the contract. 11 and 12 of the Indian Contract Act deals with these two requisites. So it is stated also there in section 11 and also 12, that if any party is regularly sound mind but occasionally unsound mind, then he cannot enter into the contract during such unsound minded state. And conversely, if he is regularly unsound mind but occasionally sound mind, he can enter into the contract when he is fit to understand the nature and circumstances of the agreement. So these are the first ingredient, that parties must be competent, which is elaborately discussed in section 11 and 12. So that is why you can say section 11 and 12, they are also connected with section 10. Section 10 is such a section, so other sections of the Indian Contract Act is connected with this. So competent parties, that is section 11 and 12 of the Contract Act. So ultimately section 10 is connected with section 11 and 12. So what I can say, that means one cell of a human body. So in one cell we know that there is nucleus, protoplasm, means other things, cavities are there. So similarly section 10 is like the nucleus of the Contract Act. Other sections are connected with the section 10. Section 10 is the center. All other basic sections, various important sections are directly or indirectly connected with section 10. So 11 and 12 is the first. Next ingredient is parties must agree on the same terms. That means free consent of the parties are required. Now consent is defined in section 13, that when two or more persons agree upon the same thing in the same sense, they are said to give the consent. So parties must sign the agreement, they must enter into the agreement with their free consent, which is known by a Latin term, that is consensus ad idem, that means mental matching. So section 13 says that when two or more persons agree upon the same thing in the same sense, they are said to give the consent. But what is free consent? It is defined in section 14, that a consent is said to be freely given when it is not induced either exercise of coercion, fraud, misrepresentation, mistake. So if any consent is voluntarily outcome, not induced either exercise of coercion, fraud, misrepresentation, mistake or undue influence, the consent is said to be freely given. So let us have a look that a free consent, that is connected with section 13, 14, 15, 16, 17, 18, 19, 19A, 20, 21 and 22. That means section 13, that is consent, 14 free consent, 15 that is coercion, 16 undue influence, 17 fraud, 18 misrepresentation. Section 15 of the Indian Contract Act deals with the coercion. It says that coercion is the committing or threatening to commit any act which is forbidden by the Indian Penal Code. So if any person commits or threatens to commit any act which is forbidden by the Indian Penal Code and thereby inducing any person to enter into the contract, that is the coercion. As for example, that A at the point of dagger threatens B that unless you sign the paper, I will stab you, and B, being frightened, has signed the paper. This is the coercion on the part of A. So if A induced B in this manner to enter into the contract, the agreement is void. Next is section 16, that is said about undue influence. It means that if any agreement is made between two persons, one of whom is in a dominating position, and not only that, uses that position over the other to gain some unfair advantage, that is called undue influence. If it is proved, then it is not also valid agreement. So it is said that if any agreement is made between any employer and employee, so employer is in the dominating position and uses that position upon the employee and said that you give me your valuable means ornament, a price of 5,000 rupees, but employer is asking you have to give it to me and I will give you only 500 instead of 5,000. so employee has handed over. But this consent is not given freely, that is hit by section 16, it is undue influence. Section 17 says that fraud, it means the suggestio falsi, that means the false suggestion or suppressio veri, suppression of the material fact. If the seller is aware of the material defect of the goods, and when the buyer is asking that whether the goods is good or not, he said that the good is without any defect, the good is in fine condition, and he thereby induces the purchaser to purchase that commodity. That is the fraud on the part of the seller. And similarly, section 18 speaks about the misrepresentation. It means the positive assertion of any fact, but it is without his knowledge. That means seller is delivering the property to B, which is defective, but seller does not know it. Seller thinks that the good is up to the order, means there is no defect. So, this is called the misrepresentation. So, if either the agreement is made based upon the exercise of coercion, fraud, misrepresentation, undue influence, the consequences are stated in section 19 and 19A, that in some cases it will be void, or in some cases it will be voidable. So, these are very much important, which are connected also with section 10. 19 and 19A deals with the effect of such if the agreement is not made by free consent. Then what will be the effect or consequence? These are discussed over there. And apart from that, section 20, 21 and 22 this deals with the mistake, effect of the mistake of fact or mistake of law. So, what appears to us that all these sections are connected with it. So, that means the second ingredient, free consent, section 13 to 22, these are also connected directly with section 10. And next point is, that is lawful consideration. Consideration must be lawful. So, section 2D of the Indian Contract Act defines the consideration, that when at the desire of the promisor, promisee has done something or abstained from doing something, such acts or abstinence, or promises to do something or promises to abstain from doing something, such acts or abstinence are considered basically the consideration for each other into the agreement. So, consideration, it is stated as ingredient that it must be lawful, it must not be unlawful. So, in order to validate the agreement, the consideration must be lawful consideration, and not only that, the object will have to be the lawful object will be also lawful. So, that is in section 23 and 24. 23 and 24 both are connected about the lawful consideration and lawful object. So, if it is if any agreement is made that A offered some money to B, so the condition is that B will stab C. Now, B stabs C and C dies in consequence, and B is claiming the money from A. That agreement is void agreement, void ab initio. That means from the very beginning it is void, because here the object is unlawful, because to kill a person, it cannot be a lawful object in accordance with the law. So, agreement will be void, and not only that, in addition to the penal code will be followed. That means, if the person dies in consequence, he will face the charge of murder under section 302 of the Indian Penal Code. So, additionally, apart from making the agreement void, the criminal prosecution will start. So, these are also important, that lawful consideration, lawful object, and it is connected with also section 25, which said that even the consideration is inadequate, agreement can be validly made if it is made voluntarily. That is why if any gift is made, in case of gift we know that there is no such consideration, it is made out of natural love and affection and purely voluntary in nature, but still the agreement is valid. So, that is why the next ingredient, lawful consideration, section 23, 24 and 25, and lawful object, that is section 23 and 24. So, what appears to us that all these are connected with directly or indirectly with section 10. So, section 10, its circumference is much more broader, it is not narrow, because so many other sections are connected with it. And next, it is stated that agreement, in order to be valid, it must not be otherwise declared to be void. So, let me consider now that what are the circumstances when an agreement is said to be made means which is declared as otherwise void. And section 26 states that agreement in restraint of marriage is void. 27 speaks that agreement in restraint of trade is void. 28 says that agreement in restraint of legal proceedings void. 29 says that agreement which is based upon some uncertainty, that is also void. And section 30 says if any agreement is entered by way of wager, that is also void. So section 26, that means agreement in restraint of marriage is void. So no agreement can be made to prevent any person from entering into marriage with someone else. Marriage is made out of purely voluntary in nature, but they must be major. But if two major persons marriage is solemnized as per their means will, so nobody can restrain him, that is void. And 27 says that agreement in restraint of trade is void, because if any person has the right to carry on any profession, so other person also has the right to carry on the profession, any trade, and which is also our constitutional right, that right to means right to life or right to select the way of livelihood. So agreement cannot be made to restrain any person from carrying on his means profession or trade or business, that is void. Similarly, 28 says that agreement cannot be made to restrain the legal proceedings. Legal proceedings can be drawn by a person against another, that cannot be restricted. But there is the provisions of the Arbitration Act. By virtue of arbitration, the civil dispute can be referred before the arbitrator. That is different thing, that means it can be amicably settled down. But if the arbitration clause is not there, then civil court is the remedy. So nobody's power to file a suit against another person cannot be curtailed. And similarly, a person can make a general diary or a person can lodge a FIR against any person. So criminal cases cannot be also restrained by virtue of this section, because criminal proceedings also are beyond any arbitration. So ordinary court will take in accordance with the code of criminal procedure. So that means agreement in restraint of legal proceedings is void. So no agreement can be made between A and B that if you commit any offense, you are my friend, if you commit any offense in my house, you will not be prosecuted by me. Even the agreement is made, but still A can file any case against B for commission of any offense by him, because agreement cannot restrain in this way. That means legal proceedings cannot be restrained. And 29 says that if the agreement is uncertain, the agreement is void. There is an agreement that A agrees to supply B 5 liters of oil and 100 rupees per liter, that is the price. Agreement is void, because here it is not mentioned that what kind of oil will be delivered, whether it is mustard oil or whether it is kerosene oil or petrol, nothing is narrated. That means the agreement is uncertain. 5 liters of oil is mentioned, but what kind of oil, it is not mentioned. So that means agreement will become void by virtue of section 29 and also by virtue of section 30, that is called wagering agreement. Wagering means if there is any like a betting, that a cricket match is going on between two countries, India and Sri Lanka. So if anything is offered that if India wins, some person will give some money, or if Sri Lanka win, the other person will give the double. So this type of betting is an example of wagering contract. So if either of these circumstances happen, the agreement becomes void by virtue of section 10. So that's why it is stated not expressly declared to be void, as I have stated, the section 26, 27, 28, 29 and 30. But apart from this 5 ingredients, there are other additional 3 ingredients which speaks about that whether any agreement is to be made by orally or written, or whether orally or written agreement can be accepted, whether it can be agreement can be made either orally or written in nature, or it may be either. So, that is the next topic, as well as whether registration is compulsory, whether witnesses are required. So, these are also ingredients of section 10. Now, I would like to discuss those additional grounds, whether agreement can be made orally or in written form, or whether registration is compulsory or not, or whether witnesses are required or not. Now, I would like to discuss two acts for discussing these ingredients, that is, first is Transfer of Property Act 1882 and another is the Registration Act 1908. According to section 54 of the Transfer of Property Act 1882, if any sale of immovable property takes place and the value of which is 100 or more than 100, the registration is compulsory. So, registration is compulsory means it must be made in written form, because if it is orally made, registration is impossible. So, by virtue of section 54 of the Transfer of Property Act, for making any sale of immovable property, it must be made by registered instrument if the value of immovable property is 100 or more. And according to section 107 of the Transfer of Property Act, if any lease is from year to year or exceeding 1 year or reserving a yearly rent, in that case the lease agreement is to be made in written form. Moreover, according to section 123 of the Transfer of Property Act, in case of any gift of immovable property, it must be made in written document, that means registration is also compulsory. And apart from that, according to the Registration Act 1908, there are two sections, that is section 17 and section 18. Section 17 says about the compulsory registration, means compulsorily registrable document, that means which documents are to be made registered compulsorily, section 17 says, and in which the sale of immovable property rupees 100 onwards, or gift of immovable property, lease, these are mentioned. And moreover, there is the section 18 says the documents which are optional. And regarding attestation, according to section 123 of the Transfer of Property Act, it is stated that gift of immovable property requires attestation by at least 2 witnesses. So, let us have a look that first is contract to be made in written form if required by law, otherwise oral. So, Transfer of Property Act, I have stated section 54 states about the sale of immovable property, the value of which is rupees 100 or more, registration is compulsory, it must be in written form. 107, that is lease more than 1 year or year to year or reserving a yearly rent, registration is compulsory, it must be in written form. And witnesses are required. Section 123 also stated that if immovable property, then registration and attestation by 2 witnesses are compulsory. Registration is compulsory as well as attestation by 2 witnesses are also compulsory. And registration is necessary if required by law. It is in accordance with the Registration Act 1908, section 17. Documents of which registration is compulsory, it is mentioned in section 17, subsection 1, clause A, D and E. That is, A means relating to the provisions of gift, and then lease, and then sale, when the registration is compulsory. And 18, registration is optional in case of various documents, like it is stated there, will, or in case of sale of movable property. So, by virtue of section 18 of the Registration Act, will or sale of movable property can be made without registration. So, in that case agreement can be made orally. So, if we go through the 3 provisions of the Transfer of Property Act and also 2 sections of the Registration Act, so we are getting this idea that in which circumstances the agreement can be made orally or in written form, when the registration is compulsory or whether the registration is optional, and also when there is the requirement of attestation by the witnesses or no necessity of witnesses. Now, I would like to discuss about one important Supreme Court judgment regarding valid attestation, that is Abdul Jabbar Sahib versus H. Venkata Sastry. In ML Abdul Jabbar Sahib versus H. Venkata Sastry, Supreme Court in the year 1969 gets some guideline for valid attestation. It is stated that valid attestation requires at least two attesting witnesses and the document must be signed before them. So, they must see the person signing the document or giving the thumb impression. So, at least two witnesses are required and the signature or thumb impression will be given by the executant in their presence. So, have a look that ML Abdul Jabbar Sahib versus H. Venkata Sastry, AIR 1969, Supreme Court 1147 page number. So, it is requisites of a valid attestation and two important guidelines, that is attestation by two or more persons are required and each attesting witness must see the executant signing or putting the thumb impression. So, I am concluding here with the discussion upon section 10 of the Indian Contract Act, and it appears toward that section 10 ambit is very much broader and which is considered as very important section of the Indian Contract Act itself, and other sections how they are connected with section 10. So, that is the scope of section 10 which is connected with various other sections of the Indian Contract Act, and which speaks about what are the similarities between the agreement and the contracts and what are the dissimilarities as well.